Oh, this is a good one here from Ebenezer. And this is something that's going to be unique to each state. So Jake and I can both touch on it. So, child's grandmother is getting involved in decision making against my orders. Or I'm assuming that means against your kind of will or against what you want. Is there a way to restrict or limit such influences? I'll kind of take the California side of that first. In California, there are grandparents' rights, but they're extremely limited.
Mm-hmm.
The state of California favors biological parents, if they're fit, willing, and able, should be the ones caring and making decisions for the kids. Now, knowing a lot of the situations I deal with, what you're most likely talking about is we'll refer to her as mother-in-law, essentially being the point person and decision maker for all the major decisions for your child. Um, that one's a little bit tougher to tackle, and it's a little bit more of a candidly. I know you're in LA. That's a trial type question. Who's really making the decisions and proving that? But in California and in most states, there's a heavy preference to biological parents. So let's just say grandma's making the decision for mom and is the one doing all the caretaking. And then when the child's with you, you're the one doing all that stuff without much help. The judge is probably going to look favorably on you because you're the biological parent that is doing the most actual parenting. So I'll pass it over to you, Jake. What are grandparents' rights like in Kansas? And what would your advice be in a situation like this?
Grandparents' rights are in Kansas are a lot like what you described in California. They're limited. If you file for grandparents' rights, I'm actually getting ready to do it in a couple cases for some grandparents. It's a two-pronged test. You have to have a proven, substantial relationship with the child, and it has to be in the child's best interest. But then grandparents also have to pay for the parents' attorney's fees that are going to combat that. So they might get 4 hours on a Saturday once a month, but it's extremely limited, kind of like what you explained. Now, if it's an instance where, mom's mom, the ex-mother-in-law, is kind of taking control and making decisions on behalf of the child, that leads to a question as to how much time is the child actually spending with mom if the child's spending all this time with grandma. Being aggressive, if it gets to this point where mother-in-law is being that overbearing, I file a motion to modify just to get her on the stand. And then if she's that overbearing and that kind of forward with it, that would be a very exciting cross-examination. I would want to see just how much control she thinks she has because, like you said, in California, there's a presumption to let parents be parents in Kansas. Actually, that's constitutionally let parents be parents unless it's proven otherwise. So if you've got custody and visitation time, then you have met that burden. You deserve to be constitutionally allowed to be a parent. And if she's trying to interfere with that, that's not in the child's best interest, and that's going to work against her. She might not know it while she's saying it on the stand, but you can use it against her. So that's what I would do.
Yeah, that's exactly. I mean, it's definitely a situation where you're going to want to get her on the stand if she's the one calling the shots.
And probably what's most exciting is you kind of feed when you're facing an opposing party like that. You feed the ego and kind of let them dig themselves in because they don't know that they're burying themselves. They're just answering the questions thinking they're right, they're in control, all of those things when they shouldn't be in control at all because they're a grandparent. They're lucky to even have parenting time, or I call it parenting time. They're lucky to have visitation. So when they overstep that bound and they take control, that's working against them.
100%.